Good afternoon, everybody. Our scheduled start time is right about now, but I'm going to give people a little extra time to join the webinar. While we're waiting, I would ask that everybody take a moment to read the disclaimer on their screen. It basically says that nothing on this webinar constitutes legal advice, and nothing said here today will be subject to attorney-client privilege. Okay. Let's see. Looking at the attendee list, appears that pretty much everybody who's signed up seems to be in. So welcome to our estate overview planning overview webinar. Thanks for joining us. My name is Dave Rodman, and I am the founder and managing partner of the Rodman Law Group. Our firm is best known for the work we do in our four largest practice areas, which are marijuana, hemp, distributed ledger technology, and civil litigation. That said, estate planning is something that all of our clients should be thinking about, because no matter what industry they participate in, they will all be impacted by death and taxes at some point. So the purpose of this webinar is to give a very broad overview of the importance of estate planning from a personal standpoint. Now, estate planning and business succession planning go hand in hand, and unlike many law firms that focus on one or the other, we help our clients integrate them seamlessly. But because of the time constraints, we are going to focus on personal estate planning today and kind of not deal with business succession. Now it is my great pleasure to introduce our panelists. Joining me today are Jeff Wilson and Dan Sweet. Jeff heads up our trust and estates practice at our firm, and Dan is a tax and estate planning attorney with an extensive background in this area. They know themselves best, though, so I'm going to let them round out their backgrounds for you. Dan, do you want to start?
Yeah, thank you, Dave. I appreciate the opportunity to be here today. I'm pretty excited about this. As you said, my name's Dan Sweet. Background includes some pre-law background in aviation, financial sector, law enforcement. I ended up getting a master's in taxation after law school and primarily focus on business like you guys do and estate and tax planning. So that's kind of the aspect I do. And I appreciate your comment that said estate planning and business planning go hand in hand. I see many times lawyers are good estate planners or good corporate attorneys, and they fail to connect those two so many times. So I appreciate you bringing up that those are very real and important aspects in any person's life. So I thanks for letting me be here today.
Absolutely, we're very excited to have you. I know personally that I always learn something when you and I talk, so I'm excited.
Same here.
Jeff, why don't you talk a little bit about yourself?
Good afternoon, Dave. Thanks for having me. Yeah, my name's Jeff Wilson. I'm a DU law grad. Been practicing law for 6 years now. I do a lot of practice in the cannabis space. I'm actually currently the chair of the Colorado Bar Association Cannabis Law Section. But I've also started to expand my practice more and more into estate planning. It's an area that I think is there's an urgent need for a lot of clients. I think a lot of people, even outside of pandemic, don't think about, what happens with their body, with their money, how do they carry on their legacy, and estate planning is essentially the vehicle to achieve all of those goals. And I just find it to be a very interesting practice area and one that's extremely helpful for just about everyone.
Well, thanks, guys. Let's jump right into it. Why don't we start with a little bit of background for those who may not know? Can you broadly explain what an estate plan is, so we have some sort of context for the rest of the conversation?
Sure. So an estate plan is essentially a variety of legal documents, and there's a handful of different tools that can be specifically tailored to achieve your specific goals or to address your specific needs. But the point of these documents collectively is to create some control over both your person and your property, both during your life and at death.
Okay. So what can happen to someone if they don't have an estate plan while they're alive?
So in the absence of an estate plan, the law does have baseline defaults in statutory law. But of course, if you don't have a estate plan, you're subject to the whims of the law. Your specific desires may not be achieved. So for example, during your lifetime, if you were to become incapacitated and you don't have a power of attorney in effect, you can't you can't choose necessarily who's going to manage your finances. And in order to manage your finances, someone will have to go to probate court to seek appointment of a conservatorship. Conversely, if you have a power of attorney for finances, that individual can start acting on your behalf right away or at the time you're incapacitated, as the case may be. Likewise with guardianship. If you don't have a medical power of attorney, or an advance directive is a little different but similar, you can wind up in a situation where if you're in a vegetative state, your family members or your doctor doesn't know what to do. There's not clear instructions. There isn't someone who's granted the decision-making authority. And again, in that case, an individual seeking to take care of you would be forced to go into probate court to seek a guardianship.
I like to add something to that too as well, Dave. I think one of the biggest things I find estate planning does is what Jeff said, is it allows the client to give some direction. One of the amazing things I find with clients is they never really thought about what happens if I get in a car accident and I can't make my medical decisions. They just assume that it's just going to work out. An estate plan allows the client to predetermine those things. It also allows the client to actually sit down and talk with their family members and their agents, if you would, and we'll get to that in a second, about their desires, so that when it does come to time to make medical decisions, your family know what you want to do and they can implement it. So it's about thinking about pre-planning and not leaving your life's decisions to the whim of a judge, the whim of your legislative body who drafts these statutes. So for me, it's about control and about planning and about discussion.
Gotcha. Those are really good answers, guys. Let me change the question a little bit. What happens if someone dies and they don't have an estate plan?
Well, I mean, that's a complicated question that's probably ultimately beyond the scope of what we're going to talk about today, but that's almost, again, the point of why to have an estate plan, and that is there are what's called intestacy laws, which are the laws that govern what happens if you die without a will, or if you don't have a trust, or if you don't have some other estate plan in place to distribute your estate to your heirs, your beneficiaries, or which can be individuals, family members, friends, could be charities, could be businesses. I mean, pretty much it's up to you. But if you don't have a plan in place, the state defaults will come into play. And actually, the last line of the state default is ultimately as cheating to the state, meaning that in certain cases, the state can wind up with your property.
And back to those testate rules, they're fascinating. In today's age where you're in your possibly your second or third marriage and you don't have kids with your current spouse, those default rules can do some really weird things to your property and not necessarily go to what you might think the default would be, which would be your surviving spouse. So again, it's about control for me, controlling where your things go, your assets go, instead of it defaulting to some rules that you probably don't even understand. So
I would just add one other thing too that Dan kind of touched on earlier, which is having clear control, having fiduciaries, a personal representative lined up who can take control of your estate. Because while the state does have default laws in place, those laws aren't effectuating. You know, they don't automatically take control and start distributing your estate. You know, it can be a real complicated legal mess if there isn't essentially a clear roadmap of how your estate should be distributed.
Gotcha. So broadly, who should be thinking about having an estate plan, or more specifically, who should have an estate plan in your mind, guys?
Yeah, that's an interesting question. The simple answer is everybody over the age of 18 or 18 or older. That's the simple, direct question. But in reality, young adults probably don't have a lot of assets to deal with. One of the things I tell people, it depends on the size of your assets. Are you married? Do you have kids? Are you in a blended family where you have kids from another spouse? So to say that it's really direct is really difficult. Again, I find that people who want more control over their lives really get into the estate planning side. I say as soon as you have any kind of substantial assets or you have some kind of dependents, okay, a spouse, kids, or what you touched on at the beginning, if you've started a business, a startup business, and you want to preserve that where it goes, then you do need an estate plan. One of the other things we use an estate plan for is just starting a legacy. A lot of people care about, hey, I got this passed down from my family. I want to pass it down to my family or my descendants. If your estate plan can be tailored for you to pass on a legacy that you've always wanted. And so, honestly, I mean, Colorado law says you got to be 18 to put a will together. So anybody over the age of 18. But if you have something that you value, you definitely need an estate plan. Back to powers of attorneys, like Jeff had mentioned before, if you want to control who's making decisions for your finances and your medical decisions, you've got to put an estate plan together.
Okay. Jeff, do you have anything to add, or I think that was a pretty solid answer there?
I think that's a great answer. Yeah, I would just say that one of the pieces, a lot of the time, I think when people think of an estate plan, they think of, oh, what happens to my stuff when I die? And knock on wood, for most of us, that won't be for a long time. And so you think, well, it's not that important. But like Dan touched on with the powers of attorney, a real risk for a lot of people is becoming incapacitated and being unable to take care of yourself. And, you take that for granted every day. But, while you may not be dead, there may be, you need a power of attorney in place, even for something that's not kind of thought of as traditional incapacitation. For example, a lot of the time, individuals that wind up incarcerated may need a power of attorney because they can't handle their, financial affairs while they're in custody.
Yeah, we've had a couple clients, unfortunately, that have had to deal with that. So having established the importance of having an estate plan, is it one of those things where you can kind of set it and forget it, or does it ever need to be revisited and revised?
Oh, life changes, right? Like today is not tomorrow. And so anytime there are substantial changes in your life, I think it warrants a look at your estate plan. I tell clients come back a minimum of every 5 years to at least take a look at it. It is amazing how, 5 years goes by quickly, but so much can happen in 5 years that you don't really know how life has changed for you. So I would say broadly, any major life change, marriage, divorce. Divorce is another one there. Yeah, one of the things we really use estate plans for nowadays are the blended family concept. You marry somebody with kids, and then you have kids together. How do you manage that? So that would be important. One thing people don't really think about is re-looking at their estate plan when they've gotten an inheritance from their family. Okay, that's, that could be substantial assets, very unique assets. How do you deal with that? Another thing that people don't realize is if you find out that you are yourself a beneficiary to a trust that is out there right now, that trust document you have a right to look at. And sometimes those documents say, hey, your portion, you can decide where your portion goes if you die before the settlor of that trust. But you usually have to follow very specific instructions. So if you find out that you are in fact a beneficiary of a trust, then we got to get our hands on that. Another thing is if your agents on your power of attorney, you've named your brother to be your financial power of attorney and he ends up passing away, you probably want to take some time to look at that as well. But at least I have people come back probably every 5 years just because, some laws change, life changes, etc. Contrary to popular opinion, you do not have to necessarily come back as soon as you have a new child, okay? Most of my trusts are drafted in a way that you could keep having kids and the trust will or excuse me, the will or your life or your estate plan will continue to work just fine with additional kids. It doesn't hurt to come back, but it's well worth it. If you find out your child has special needs kid, and we're seeing that occur more and more, then you definitely need to readdress your estate plan.
Okay, that sounds pretty logical. We've been talking about the estate plan and the scheduling of estate plan, but let's dive into it for a second. What are the key items that make up an estate plan? Explain to people what we're talking about here.
I can jump in on that. Actually, one thing I just add on the last topic too is one other time that it may be valuable to revisit your estate plan is if you move states.
Oh, absolutely.
If you move to a new state, because estate planning is, it's a hybrid of both federal and state law, but because state law plays a huge role, if you change states, that's another good time to revisit your estate plan. But as far as kind of the basics of an estate plan, most people are kind of familiar with the first aspect, which is a last will and testament. Essentially that's the document that's going to give away your stuff when you die. Now, similarly, there's also what's called a living revocable trust. It operates somewhat similar to a will, but a little different. Those are kind of the more testamentary, the at death sort of documents. Now at life, the other aspects of your estate plan are a power of attorney, a medical power of attorney first, which provides an agent to make medical decisions on your behalf if you're unable to do so. Second is a financial, also sometimes known as a general power of attorney. And that's the person who's authorized to make financial decisions on your behalf. And then last is what's known as an advance directive or a living will. And that's essentially a document where you state your wishes with respect to prolonged life due to medical procedures. So artificial nutrition, hydration, things of that sort. Stated coarsely, it's essentially kind of the when to pull the plug document.
Gotcha. So let's take each one of those in turn and just get a little bit more specificity. So the powers of attorney, both medical and financial, why would a person need one, and can they have more than one?
So yeah, let's take those as separate topics here. So first, looking at the medical power of attorney. Why you need a medical power of attorney is so that you provide clear authority to someone to make medical decisions for you if you become unable to make them for yourself. one of the things that can happen is if you don't have a medical power of attorney, it can be a difficult situation when maybe your spouse feels one way about your medical treatment, your kids feel a different way. Maybe even like Dan mentioned with blended families, I mean, maybe you even have an ex-spouse that, feels one way that you had a good relationship with. So, and maybe your brother, your sister, everybody has feelings about how they want a loved one cared for. But by creating a medical power of attorney, you're stating that, one or more persons has authority to make decisions on your behalf. And just to touch on that piece real quick, because you kind of said, can you have more than one? I mean, the general answer is yes, but that's not necessarily because it's a good policy. As a general rule, in most instances, I would recommend that people only have one agent. If you name more than one agent, things can get a little more complicated. Now, for something like a financial power of attorney, which we'll turn to next, I mean, in certain instances, having two agents and letting them act independently can be helpful because administering a person's estate can be a lot of work. And, if you have two trusted people that you think can operate independently, that's fine. But conversely, in other instances, if you have more than one agent, sometimes people want them to act jointly. And this is often true in the medical power of attorney concept because, you think, oh, well, I have two kids. I want both my kids to make my medical decisions, for me. The problem with that is that it can defeat the purpose of the medical power of attorney almost if your kids end up disagreeing, because it can lead to stalemate at the crucial time when you need someone to make the decisions that you can't make. So kind of to turn over to the next piece, the financial power of attorney is, akin to the medical power of attorney, except in the financial context. This is the document that allows someone to go to your bank and conduct your banking transactions, to act on your behalf with respect to the IRS and your tax obligations, to deal with, any life insurance you may have or homeowners insurance. I mean, essentially all aspects of your financial well-being. And, generally speaking, medical powers of attorney don't really take effect until you become incapacitated, because for all practical purposes, you are going to make your own medical decisions up until the point that you can't anymore. Financial powers of attorney, on the other hand, they can either be springing, which means they don't take effect until you become incapacitated, or they can be presently effective. Which is right in a certain circumstances depends on the client.
I'm going to throw a couple things in there if you don't mind. One of the things I think it goes back to what I said, you got to talk to your family. Like it doesn't do a whole lot of good to name your sister as your medical power of attorney if you don't talk to her about that. Most of the time when it comes to agents, we name the other spouse, but I've actually had clients tell me that if my spouse was in a car accident, I would not be emotionally able to make those medical decisions on their behalf. So can we name, somebody else? And absolutely, we can. These things are all tailored, but the bigger thing is for me is stop and think about it, and then talk to your loved ones about it. And that's probably the most important thing in my world.
Gotcha. So does it make sense, or is there an obligation for you to have one person be your medical power of attorney and other person be your financial power of attorney, or can they be the same person? What's the best practice?
It can be the same person. I mean, this is really, again, a case-by-case determination. I mean, kind of like Dan said, I mean, the defaults for many people will be that their spouse is their first choice agent. Now, in both of these documents, both the medical and financial power of attorney, you can name a contingent agent and maybe even a second successor agent, so that in the event that your primary agent is unable or unwilling to act, which can be for a variety of reasons. I mean, either because they've passed away, or because they're suffering from such medical conditions that they're no longer in a position to act on behalf of themselves, let alone someone else. Or, I mean, simply because maybe they are overburdened and they just don't have the time to help. But in any event, it's generally a good policy to name a contingent agent, also sometimes called a successor agent. Now, kind of back to your original question of, is it better to have different people? I think that really just depends. I mean, I know sometimes one thing people will do is, if you have two kids, to avoid the situation where you say, oh, I want my kids to, work together. Sometimes people will name one of their, one child the primary agent on, say, the financial POA, and then the second child is the primary agent on the medical POA, and then, the two kids will be the alternates or the successor agents on the other documents. But there's no rule that says you have to do that. And in truth, I mean, it all goes back to what Dan was saying, which is talking to your family. And, in truth, really what it comes down to is picking the people that are going to be best for you, that you trust, that, will be able to handle these responsibilities. And if that's the same person, great. And if it's a different person, that's also great.
So what's the difference between a medical power of attorney and an advanced directive? They sound sort of like they might be similar.
The living will, the advanced directive, a similar thing that people sometimes refer to, or that's a similar concept, is a do not resuscitate order. Basically, that's a narrower purpose. So the medical power of attorney is creating essentially a general power for that agent to make healthcare decisions. Now, if you don't have an advanced directive, that person can basically make whatever decisions he or she wants on your behalf for, with the duty of, in your best interest. But now what an advanced directive does is it allows you to answer the hard questions about life and death for yourself in advance. And in a way, the advanced directive is often a gift to your medical power of attorney, because what it does is it takes the tough decisions that they would have to make, that they're going to have pressure from other family members, from friends, maybe from even the medical community, and it says, listen, I have this advanced directive. This says what my wishes are to be under a circumstance where my life is being prolonged by some sort of artificial means. And so you take away that pain almost of forcing a family member, a loved one, to make what may be the hardest decision they've ever had to make with respect to your health and well-being, and whether to end your life.
I fully agree. I think taking the burden off your family is one of the most important aspects of an estate plan. I couldn't agree more.
To just kind of dive into that a little bit more, besides the fact of taking that gift away from somebody, from a family member, are there any other consequences for not having an advanced directive?
Well, certainly, I mean, and it's a very personal decision, of course, with the advanced directive, as far as, whether you do want your life prolonged as long as possible. And if you do, what sort of procedures are you, willing to accept? I mean, certainly for some people of certain religions, certain faiths, certain types of medical procedures they view as, unholy, undesirable. And if you don't have, a medical or advanced directive in place, and, there isn't a clear order that you're not to be treated in one fashion or another, it's possible that you'll end up being treated in a fashion that you never wanted to, that's inconsistent with your personal, or spiritual, or both, beliefs. And that's one big piece there, is that, again, it goes back to kind of where we started with control, but also with, making a clear picture of what you want to happen in, the worst of times.
So I probably should have said this for our audience earlier, that we're going to be answering questions that anybody might have at the end, but there's a couple that are piling up. And I think this one is a good one, given the point that we're at, and that is what happens to, what kind of liability is there for people who are medical powers of attorney and general powers of attorney who don't act as they should? You know, they or even more specifically, what if you've conveyed to somebody that you do not want to be resuscitated, but then you are resuscitated and you know you recover? Is there any kind of legal thinking on those type of things? I'm sure there's some fiduciary things that we get into on the financial side, but I'll let you guys, you know, take that one as you will.
I mean, the simple answer is absolutely. I mean, when you're acting as an agent under a power of attorney, either medical or financial, you have a duty to act in the best interests of the principal. That's the individual who creates the power of attorney. You know, if you fail to meet that duty to actually act in the principal's best interests, you can become liable to the principal. You can become liable to the principal's estate if the principal dies or if the principal is unable to act on behalf of themselves. I mean, the extent of such liability is always going to be a fact-intensive, you know, evaluation in terms of, you know, what exactly did you do and what exact harm did it cause. But the simple answer is absolutely. As an agent under a POA, medical or financial, you have a duty to act in the best interest of the principal.
So this is fascinating to me, and so just humor me for a second. I want to drill down on this. So let's say you had a DNR and you said you didn't want to be resuscitated. You're resuscitated, you recover, and all of a sudden you have a ton of medical bills. Is there any argument to be made that the person who failed to pay attention to your request to not be resuscitated, can they be on the hook, or are those damages inverse damages because you're fundamentally alive?
That's a tough question. I mean, I don't know if Dan, you got
I mean, I mean, the one thing about resuscitation is the ultimate person making the decision to resuscitate is the hospital or doctor, the EMS, right? Like your agent doesn't have the authority to say, don't resuscitate or resuscitate. So, you know, I'm going to guess, and I don't do civil litigation, especially in the med-mal world, but I'm going to guess that your doctors are going to err on the side of caution there and resuscitate to the extent that they are not absolutely sure about it. And then, I mean, the argument is, like Jeff's saying, very fact intensive, right? And is your argument that, hey, I'm alive, I didn't want to be, now it's everybody's fault? That's a pretty tough argument. So it's a very interesting question, somewhat beyond the scope of what we're talking about. But yeah, definitely a fascinating question. I think where you find most of this is somebody has a financial power of attorney and they go in and they sign the deed on somebody who's incapacitated over to themselves. They go sell it and they go on a vacation to the Caribbean, right? Like that's a pretty straightforward, you did not act in the best interest of the incapacitated person. And people do that, guys. People do that, and liability is pretty strong against the agent in that case.
Yeah, I mean, one thing I'll just chime in there that we kind of glossed over, but I mean, I want to go too detailed is, you know, under a financial power of attorney, I don't actually know off the top of my head these days, Dan, you might, but I think it's approximately 30 states have adopted the Uniform Power of Attorney Act. Colorado is one of them. And under the Uniform Power of Attorney Act, the default rule is essentially that the agent cannot benefit themselves using your property. Now you can change that. You can add what are known as hot powers to let the, you know, the agent take your property, to let the agent, you know, self-deal. But generally, you know, as a kind of default rule, the agent can't just take your property wholeheartedly, but that doesn't mean that they won't. And that, you know, the power of attorney is always kind of limited by who is the person acting on behalf of it, who's the recipient of it. And as a general rule, powers of attorney laws are very favorable to try to induce third parties to accept powers of attorney. And so, You know, if your agent goes, and this is why it's so important that whoever it is that you name as your agent is trustworthy, that if they go and, you know, represent to your bank that they have the power to withdraw all the money and the bank gives it to them, you know, you're probably not going to have, you know, there's probably not going to be a claim that's possible against the bank. The only claim would be against the agent. And if the agent's, you know, a person of poor character already, for all you know, they're long gone and that money's long gone.
Makes sense. Well, thank you for indulging those questions. We're going to leave the rest for the end, so keep them coming, audience. Let's get back on track, though. The last will and testament. What is a last will and testament? I'm sure that most people have a conception of it, but as with most things in the law, I would say the average person probably doesn't have it all the way conceived of perfectly.
So last will and testament is kind of fascinating because we use it loose and we've heard it since the day we were born, right? Like loose and fast, and we don't really really understand what it is. What we've been talking about up until this point is estate plan documents that have to deal with what's happening while I'm alive. Power of attorneys, advance directives. Last will and testament kicks in at the time of death. At the time of death, your general power of attorney goes away. It's void. Your medical power of attorney obviously goes away. And your last will and testament steps in as the power of attorney, if you would. It also allows you to name fiduciaries, people who are going to watch over your stuff after you die and distribute it out in a way that makes sense, or the way that you've designated in that last will and testament. So it names fiduciaries, it names beneficiaries, like where does this go, where does that go. A last will and testament allows you to give specific gifts to somebody, as well as just, hey, you know, split my estate into thirds and give it to each of my 3 kids. So it's somewhat flexible. One of the things that if you do it correctly, your last will and testament can actually disinherit one of your descendants. Contrary to popular belief, at least from what I've seen from clients, is they believe they can just name 2 of their 3 kids and only those 2 get something and the 3rd one doesn't. Well, under Colorado law, if you want to disinherit, quote unquote, disinherit somebody, there are very, very specific things you have to do in order to effectuate that. A lot of times, not a lot of times, let me rephrase that. If you do not want to give everything to your descendants, your last will and testament will, if drafted correctly, allow you to give a portion to your descendants and then maybe another portion to somebody else or a charity. Again, if you don't have the last will and testament in place, you are stuck with the Colorado or whatever state you're in laws on where do we send the stuff? What does the statute say? And honestly, even though the statute generally makes sense, it's not always that's the case. So for me, the last will and testament is ensuring that you get the right people looking over your assets. You make sure your assets get to the right people, and provide control outside of the law. Generally, a last will and testament is prepared by an attorney. You can do some handwritten ones, but that don't do it because there are very specific things you have to do on those, and a lot of times it doesn't get done, and so the will is invalid and you're back to the statutes. So no matter how complicated or how easy you think your estate plan is, at least have a professional look over it. I've seen estate plans done offline, whether it's like, oh, this financial planner gave me a document, or, you know, this service gave me a document. More often than not, those create considerable problems and cost you so much more to administer after your death than it would to ever just have one drafted correctly on day one. I just got out of some major litigation where we're talking hundreds of thousands of dollars got lost because somebody didn't want to spend a couple $1,000s to do an estate plan correctly 6 years ago. And I'm talking hundreds of thousands of dollars. So I don't like to scare people into using professionals, but from experience, your last will and testament and your estate plans should be done by a professional. We're going to get into trust in just a minute, but your will may not say, hey, give this specifically here or divide my estate and give it to my kids. What it might say simply is take all my stuff and throw it into my trust. We call that a pour over will, a will that essentially just pours everything over into a trust document. I like that because when it comes to making any kind of amendment, if I amend a will, okay, it requires witnesses, signatures, notaries, and all that stuff. But if I have a trust, or excuse me, if I have a last will and testament that just pours over into a trust, I don't have to touch this will anymore. I can modify and amend the trust in a much more fluid and honestly cheaper way than always amending a will. So we call that a pour over trust, or excuse me, a pour over will that just pours everything over into a trust. But to recap, your last will and testament names fiduciaries to look over how to administer your things. It takes certain items and gives them away specifically or generally to a group of people or persons. Again, it's about control so that you can decide where your things go and that the state of Colorado doesn't decide for you.
If I can just jump in real quick on that before we move on to trust, I think I just want to re-emphasize kind of a point that Dan touched on, which is kind of that one of the things your will could really do is avoid expense later. And in Colorado, we have self-proving wills and informal probate administration, which means that if you have your will drafted correctly with the help of a professional, you have the right witnesses and the notarization, when it comes time to administer your estate, there's an easy, relatively easy, quick probate process in Colorado that, the court just accepts your will and then your personal representative can start, administering your estate. I mean, subject to complying with the probate code. Conversely, if you do have, a handwritten will or a poorly executed will, there is a possibility that that will still be honored, but it's not easy. It's not guaranteed. It will require many more hours. It will almost assuredly require the involvement of an attorney. And at a minimum, even if it is accepted, in addition to the cost, it can also cause substantial delay between the time that the court approves your will and when your beneficiaries ultimately take your property. And in some instances, that can be significant because property doesn't necessarily do well just sitting by itself underutilized. And if you don't have a personal representative who's doing a good job of taking care of your property, what your beneficiaries receive may be in much worse condition than what you would have envisioned.
Absolutely.
That makes sense. Dan, I want to ask you a little bit more of a specific question on that. You mentioned when you were talking about the things that people have gotten off the internet. Is that a reference to something like LegalZoom? And is that sort of are we saying that that may result in saving a little bit of money now and then losing a bunch of money later, or your heirs losing a bunch of money because it's not as effective as a old-fashioned will that you go in person to a lawyer to get?
So there are multiple online estate planning services, and I find them all problematic because they're designed to meet the needs of the basic middle 30% of America or something. They cannot be they cannot be tailored, or if you tailor them, you probably tailor them incorrectly and don't achieve what you really want. And that's where I see things go amiss. they'll say like, oh, let's just erase this line and put some language in there, and they use words that in the legal world don't make sense, or they completely conflict with each other. I've seen self-generated documents that use words that in their mind meant something, but in the legal world meant something very specific, and it either added too much power or excluded the necessary power. And so sure, if you are going into the hospital tomorrow and you have failed to do your will and you want to print something offline because you can't get a hold of your attorney, maybe there's some validity in that. But outside of like some really far-reaching circumstances like that, I find that large service providers on the internet create long-term problems when it comes to, as Jeff said, trying to administer it. Because if you have a will that you can run down to the probate court, slap it in there, get it administered in 3 weeks, great. But if you have a will that's a little funky or somebody decides to contest it, 2 years later, you've lost so much money and you haven't had access to those assets. So
yeah, I mean that jives perfectly with my experience in the corporate world. Without fail, every single client that has come to me with a legal Zoom type charter document has inevitably spent so much more money trying to correct any issues that have arisen. So I was curious. So let's move now to what actually I was most excited for on this discussion personally, and that's trusts. Of trusts and estates. Dan, can you talk about the use of trusts in estate planning versus tax planning?
Oh, absolutely. And one of the first things I want to mention is we could spend here for 3 hours talking about trusts. And so my intent is not to do that. My intent is to kind of hone down how we use trust in a typical estate plan.
Actually, Dan, this might make more sense. Why don't we back up a little bit and just explain what a trust is quickly for.
Absolutely. Yep. So we throw this word trust around so much, right? Like trust this, you need to trust this, whatever. And a lot of times it doesn't make sense. What a trust is a relationship, Dave. It's a relationship between the settlor. The settlor is a person who drafts the trust and puts stuff in it, okay? There are beneficiaries. Those are the people who have a right to the assets either right now or later on after the settlor dies. And then there's a trustee, and that's the person who's in charge of this stuff. So it's this relationship of 3 groups of people that are following an instruction manual, and that instruction manual is the trust document, okay? And so the settlor, what's nice about most trusts is you can do about anything you want in there, get super creative, and then you hand off all the assets to the trustee, okay, who follows this rule book, okay? And this rule book can vary. And so it's really a relationship. Then it's not like in the corporate world, oh, I have a business. It's over there in the shop, right? It's at an address. A trust is a relationship that everybody is promising to follow a document, a rule of instruction. Does it make sense?
Yeah, very, very well said. So sorry for interrupting you earlier. Let's get back to the difference between using a trust for estate planning and using a trust for tax planning. I know that they're using both places.
Absolutely. So we use trusts in tax planning all the time, and if you have a really large estate, you may want to set up tax planning trusts. That's way outside the scope of the average estate plan now, but they're complicated. You have to have a professional draft those up for you. Another type of trust would be one we use for Medicaid. Okay, there's the Medicaid trust that we put out there that allows somebody to get on Medicaid even though they have more assets than what would normally allow them to be eligible for Medicaid. Again, that's kind of outside, it's a specialty kind of trust. It's outside of what we're talking about today. What I want to talk about today is your typical revocable living trust. Revocable means I can change it. As a settlor, I can change it. We all love to change our minds. So the revocable living trust is a great estate plan tool that allows me to change my mind. The living part means I set it up while I'm alive. Okay, so a revocable living trust would be a trust that I use to, in conjunction with my estate plan, that I set up while I'm alive. Most of those trusts, I'm the trustee, I'm the settlor, and while I'm alive, I benefit from the assets. So it's very, very friendly. Okay. The nice thing about it, I hear a lot of clients come in and they say, oh, my neighbor said I need a trust, or I saw something on TV that said I need a trust, or my financial planner said I need a trust. Let me go through the 5 things that I look for to determine if a client needs a trust. And if they meet one of these 5, I'm pretty aggressive at pushing a trust on them. Okay, otherwise I don't really care. But in order for us to go through those 5, we have to understand what happens at death. And Jeff mentioned this just a few minutes ago. When you die, you have a will only, we got to run down to probate court and probate this will. Okay, everything is that you own has got to go through the probate process. If we don't want to go through that process, let's say, for example, my wife is elderly as well, maybe has some health issues, and as soon as I die, boom, she needs access to those funds day one. Okay, I can't run down to probate and deal with this. There are non-probate assets that do not go through probate. One of those assets is life insurance. Life insurance goes to the beneficiary by virtue of a contract. Okay, designations on bank accounts, brokerage accounts, etc. If it's contractually written on there who the beneficiary is, it doesn't go through probate, it goes directly to the beneficiary. A trust is a contractual agreement with named beneficiaries. Therefore, if you have things in a trust at the time of your death, those things do not go through probate. Okay, so a trust is a way to allow you to take normal assets that normally go through probate and circumvent probate, okay, and make those assets readily available the day you die. That's important when it comes to access. The other thing that happens in probate is you have to fill out a document of everything you own and file it with the court. So if you're a very private person and you do not want that privacy exposure, then a trust is for you, for sure. Okay. Another time I recommend trust is if we have a blended family. My spouse has kids, I don't, but we together have kids. I may want to take my inheritance and my assets and ensure that it goes to the kids that I have with my spouse and not necessarily flow down to her kids. Okay, does that make sense? A trust allows me to ensure that I have determined the ultimate disposition of my assets, even though after I die, my spouse may be able to use my assets. But ultimately, I can control where that goes. Blended families is another great place to use a trust. If your kids are young or there's some responsibility issues with your kids, a trust is a great way to say, hey, at 18, you get this amount of money. At 25, you get this amount of money. At 30, you get this amount of money. That can be controlled in the trust. One of the things that I see clients have now more than ever is assets in other states. Probate requires you to probate every asset in every state at the state level. So for example, I see this all the time. Clients come in, they go, granddaddy gave me oil and gas rights in Texas. Okay, if you die, I got to run down to Texas. I got to get a Texas lawyer. I got to take those assets, run them through Texas probate court, just so that I can retitle the oil and gas in your kids' names. So if you have assets in multiple states, especially California, New York, and Florida, where there's notorious high cost to run assets through probate, you got to set up a trust in order to hold those assets so we circumvent the probate system, okay? If you have an estate with very, high value estate that doesn't maybe reach the taxable level, but reaches the level where you don't want to cut your kids, a $3 million check at the time of your death, then we need to look at preserving those assets in a trust. Finally, if you have any kids with special needs, okay, who might be eligible for government payments, government subsidies, etc., you've got to get a trust together for those kids. So if you meet those 5 or 6 items, I will push you into a trust. So that's what a typical revocable living trust does. Is it's set up in life by me for my benefit, and I'm the trustee. I can change it at any time. So it's very flexible, but it allows us to meet the needs that these 5 or 6 items present to us. Does that make sense?
Yeah, thank you.
Oh, absolutely.
So you said the words irrevocable and revocable trusts in this conversation. Can you give our audience a sort of a quick descriptor of what the difference between the two of them are?
Absolutely. So revocable goes back to I can amend it at any time. Irrevocable says I'm going to write this trust up and I can't change it. And once I put something in it, or what we call in the legal world funding of a trust, when I fund it and put something in it, I can't change it. Okay. The only time you really see irrevocable trusts are when you're doing some serious financial planning associated with possible taxable estates. Okay. And just a side note on taxable estates, I'm amazed when clients come in and say, oh, I'm only worth $2 or $3 million. And we actually start counting what they're worth. People don't realize the VAT. Like if I have a life insurance policy for $2 million, my estate is instantly valued at $2 million because that life insurance policy is included in my estate. And what's the value of a business? Oh, yeah, I don't know. Well, it's amazing if you go get a business appraisal, how much value they can put into a business. Well, when you die, we go out and get appraisals for your business and we calculate the value of your estate. Now, if you have a taxable estate and you need to do some tax planning with trusts, you usually use irrevocable trust, and the reasons for this are complicated, but it's mainly because if it's irrevocable and I can't change it, then I've relinquished control of this asset when I put it in the trust. That is a gift. It's a loss of control. And in the IRS's mind, you don't own it anymore. Okay. So if we're trying to get things out of your estate because your estate is possibly subject to estate tax, we have to show we have made a completed gift and transfer of control. The only way that you can effectively do that is to set up trusts that are irrevocable, that you cannot reach your hand back in there and grab that asset back out. Does that make sense?
Yes.
I'm always cautious about that because people like to change and amend and they love revocable trust. But if we go irrevocable, it's very, 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 very difficult to unwind that effectively because we're trying to achieve some tax purposes that requires a relinquishing of control.
Got it. Well, that is that basically covers the agenda that I had wanted to get to in this. Before we go to take questions from the audience, do you guys have anything you want to add or clarify or just continue on?
I think one thing we might want to touch on just a little bit more that Dan touched on, but is kind of how the trust works in terms of funding the trust. and,
Yes. Yep.
title of assets. Because I think that is one of the things that people are sometimes confused by with a trust. Essentially to make the living trust work, you have to fund it. And what funding it means is that you have to put your stuff in the trust. If you want your house to not have to pass through probate, you actually have to put your house, you have to use a deed to put your house in the trust. At which point the trust is the legal owner of the house, and the trustee is therefore the person who can manage the house. Now, like Dan said, with revocable living trusts, the reason that they work so well is because in the beginning, the trustee and the settlor are the same person. So you don't actually lose control of your house because, during your life, because you put it in trust, because you're the trustee or you or your spouse are the trustees. But that is an important step that, sometimes clients are able to go off and fund the trust all by themselves. Sometimes they need, especially with things like real estate or, oil and gas interests, they need help of an attorney to make sure that those assets actually do end up in the trust. Because if there's assets that don't end up in the trust, you're back to, that's where that pour over will comes in, that that can help scoop up anything that wasn't in the trust. But if you have a bunch of stuff that wasn't in the trust, it almost becomes partially self-defeating, because then you do end up having to go through a prolonged probate process.
And that's why I have clients try to come back every 5 years, because inevitably they go to North Carolina and they buy a house and they buy it in their own name. And you got to remind them that, hey, that's got to go through North Carolina probate unless we get it into the trust. To kind of put everything together and what Jeff was saying about funding, let's take, for example, life insurance. Life insurance generally goes to the surviving spouse and maybe the kids if the surviving spouse is not alive at your death. If you're in a blended family scenario, you might only want your life insurance to go to your spouse if she's alive. And if she's not alive, you may want the life insurance to pass over to your kids. What if you have substantial life insurance that would go to your spouse, and she now has all these millions of dollars and remarries somebody and gives it away to her second spouse? Very problematic. The way you fund a trust with life insurance death benefit is you just go change the beneficiary of the life insurance to roll over into the trust. The money sits in the trust. Your surviving spouse can access it for specific needs, but she, if she dies before she uses it all, then this remaining money will be able to go to your kids, and she doesn't have the access to get in there and buy 3 homes in the Caribbean with life insurance money that you honestly wanted to go to your kids eventually. So having that planning, having the funding to make sure that it gets into the right place so that you can ultimately control where your net worth goes is just part of this estate plan and why we use trusts.
So what if, just to drill on down to the funding question, if you have an irrevocable trust and a pour over will that is going to put all the assets into your trust at death, is that trust funded, or does it, what's the actual, like, there's got to be like a discrete moment where if it doesn't have anything in it, it's not funded, then you die, and then all of a sudden it has everything in it? How does that, when you say funded, not funded, how does that?
Well,
so you should fund a trust while you're alive, okay? Our pour over will concept is designed to capture things we failed to put in the trust before you died, okay? So what the pour over will does is says, oh my gosh, we forgot to put these 3 assets in the trust. Let's go probate them first and let the judge tell us that, oh yes, your pour over will says to go put it in the trust. Now go put it in the trust. We've had to probate that asset though. It eventually gets to the trust, but it's had to go through probate. So one of the things we use a trust for is to forego probate. So if we have failed to fund or transfer the asset into the trust before we die, it's got to go through probate. It eventually gets there, Dave, but we've defeated our, like Jeff said, defeated our purpose of trying to get around probate. Does that answer that
Yeah, the
question?
pour over will simply is, it's a fail safe.
Yeah.
You know, in the event of anything that got missed, it's not intended to be the vehicle to actually get things into the
Right.
trust.
Gotcha. Well, I think it's time to take some questions from the audience. I'm going to exercise moderator privilege here, though. I'm going to ask my own question first. And that is, you know, I've seen in several television shows that there is some sort of minimum amount of money that you would need to put towards a beneficiary of a will so that it cannot be contested. Is that a real thing? Is that completely nonsense? Is that creative licensing? What's going on there?
I have not heard that, so I'm gonna go with creative licensing. Jeff, have you heard anything like that?
I think what you're getting at is kind of what Dan was talking about earlier with the disinheriting. The reason people did that is because the law assumes, precisely because people don't revisit their estate plan, that you know, often people will have children later in life, especially with, you know, adoption or remarriage, or something where, you know, their will says I have 2 kids. Well, at death they have 4 kids. You know, and so the law has essentially written in some presumptions where, unless you specifically state otherwise and follow the right procedures, the law is going to assume that really when you said, you know, Tommy and Sally, you meant all 4 kids, and therefore your estate can be distributed accordingly. And so I think what you're getting at and what kind of TV is hinted at is, you know, if you write that Sally gets $1 and everything else goes to Tommy, then, you know, it's essentially establishing that you did actually consider Sally, you know, in your will, and that you did intend an uneven distribution. But as far as, you know, any particular dollar amount or whether it's necessary to leave anyone any money that you want to disinherit, but no, that you don't have to. You can leave them literally nothing as long as you do it correctly.
Gotcha. All right. So now thank you for indulging my question. Now some questions from our audience. I want to donate my organs when I die. Is that something I can put into my estate plan?
Yeah, absolutely. In Colorado, it's something you can even put on your driver's license. It's very simple. And you know, again, that's one of those areas where if you want to be especially specific about it, you can. I mean, most people don't. I mean, I'm a generic organ donor, but you know, if you wanted to donate your organs to a specific charity, or you know, if you had a specific, I mean, you've probably heard in light of the kind of current CTE situations, you know, people leaving their brains for research purposes. That's the type of thing you can achieve through your estate plan.
Gotcha. I was designated as a POA, power of attorney, but I have heard of others having issues with financial institutions accepting the POA. Should I be concerned?
You want to take that, Jeff?
Well, yeah, sure. I mean, so one of the things with the power of attorney, again, is it all comes down to kind of, you know, who is accepting it and how are they relying on it. In Colorado and the Uniform Power of Attorney states, there's kind of 2 things that help induce third-party reliance. There's essentially the carrot and the stick. The carrot is that the default in the law is that third parties are held harmless unless they have actual knowledge that, you know, the POA is valid or that invalid, or that the agent is acting, you know, beyond their scope of the agent's authority. But in most instances, the third party is going to be protected. So that's the carrot. The stick is also that if a third party refuses to honor a POA that's facially valid, there is a right of action for the agent to sue and take the third party to court, you know, get an order that the court says you have to honor this POA, and then to make that third party pay for all of the legal expenses involved in getting that order. So between those two provisions, kind of the carrot, the lack of liability, and the stick of if you refuse to honor this, you may be subjecting yourself to needless liability and attorney's fees. Most places are pretty good about honoring POAs. I've heard some stories from kind of older estate practitioners, and this actually appears in the Uniform Power of Attorney Act too, that in 20 years ago, when powers of attorney weren't as common, banks might refuse to honor a power of attorney just based on passage of time. They'd say, oh, this POA is 10 years old. Well, the irony, of course, is that, the POA, unless your agent, dies or kind of becomes unavailable, like we discussed before, I mean, most people aren't writing a POA to have it be used immediately. It is designed to be used down the road when you need it, when you become incompetent, when you might not be able to make another POA because you've lost the legal capacity to form contracts. And so as a result, the Uniform Act specifically provides that passage of time alone is not a legitimate reason to refuse a POA.
Gotcha. The next question is also about powers of attorney. I want to limit the things that the person I have given a POA to can do. Is that possible?
Absolutely. I mean, it can be customized. In fact, a lot of the new statutory short form POAs, which have their ups and their downs, a lot of the uniform power of attorney states, including Colorado, have what's called a statutory short form POA, which basically is a glorified checklist of powers that have broader definitions in statute, kind of like the intestacy laws. The problems with that is if you simply just check one section, say for real property, it's not apparent on the face of the document what that really means because the actual powers are listed in the statute. But truly, with respect to a power of attorney, you can do almost whatever you want. I mean, most of the time when we talk about a financial power of attorney, we're talking about a general power of attorney that basically provides broad authority to do anything and basically lasts forever. But you can make your power of attorney terminate upon a specific time. You can have a power of attorney for a limited purpose. I mean, I could grant, Dave a power of attorney just to sell my car. It's like, I don't want to sell my car. Dave, you can be my power of attorney. It doesn't give you the right to do anything else. You can't go to my bank. You can't, change my life insurance beneficiaries, but you can sell my car. So yeah, it can be tailored, as narrowly or as broadly as you want it, and for as long or as little as you want.
Gotcha. Well, thank you. This one is a little bit more specific. So I'm going to remind our audience that this is not legal advice. We are not your attorneys. But my will was written and signed in Texas, but I'm moving to Colorado. Is there anything I need to consider regarding my will before this move? Dan, you want to take that one?
Oh, absolutely. Jeff had made a reference earlier. When do you revisit your will? And one of them is when you change your domicile, the state you live in. But if you happen to end up in Colorado and you haven't changed your Texas will to a Colorado will, we call that a foreign will. And there is a procedure through Colorado probate court by which I can bring in a foreign will and have it adjudicated here. Okay, so it's a little, thank goodness Colorado probate is not overly taxing on us, so we can get it done. But yes, I mean, unlike a Colorado will where a lot of times they just kind of get rubber stamped at the probate court level, if it's a foreign a will, a judge is going to have to actually look at it and determine. But it is possible. But if you're moving domiciles into Colorado, we highly encourage you to look at your estate plan and reevaluate, especially when it comes into trusts, because you may have a Texas trust and you may be living here, but that thing is run off of Texas law, and you might want to change the place of the law that governs that trust. So I think that just comes down to, yeah, we can do it, but it's a good time to revisit your estate plan.
Gotcha. I think we'll take one more. That's a good one too. If I have not started on an estate plan of any kind, what would be my first step? In other words, what item is most important to execute first?
Ooh, so one of the things it's personal preference. I don't do piecemeal estate plans. We've talked about last will and testament, general power of attorney, medical power of attorney, and advanced directive. Those are the 4 that I put in every estate plan. Whether you need a trust or not, I may add a 5th one in there. So I don't do piecemeal stuff. So when I tell people, if they call me and say, hey, we want to talk about this, I give them things to think about. First of all, understand what your assets are. Just have a general understanding of the value and the debt load on houses and real property, and an idea of your assets. Very general. I don't, just very general. Next thing is have a thought or a discussion as to where you want your assets to go, so that I can have a meaningful discussion with you. Before you come in, I generally like for you to think about, hey, if I'm incapacitated, who's going, who do I want to make medical decisions and financial decisions for me? So what I would tell listeners today is to think about that stuff, give you guys a call and set up an appointment. But in order for you to have a meaningful conversation, you have had to process this a little bit. And what the big things I find clients don't process is having a good understanding of the assets they own, and then some thought process about where I want things to go. Generally, things go to the surviving spouse and then the kids, but we always want to add in there, what happens if, God forbid, we're all in the same airplane and we all die together? I don't want the state of Colorado to get my assets. So who's that charity? Who's that organization that you would want stuff to go to if none of your beneficiaries are around? If you've thought about that, I can tell you we can get a very, healthy conversation consult to get your estate plan together. Does that answer the question? Okay.
Well, guys, I appreciate both of your time very much, and I'm sure that our attendees do as well. Thank you for joining and running basically this this panel. It was incredibly insightful, and I think there was some good stuff conveyed. Thank you.
Thanks for having me,
pleasure.
Dave. I appreciate it. And Jeff, it's been a pleasure with you as well.
All right.
Yeah, thanks to you both.
I'll see everybody later.